Good afternoon, guys. Just let me know if you can hear me. Just let me know if you can hear me. So, good afternoon, good afternoon, guys. Just let me know if you can hear me or not. Good afternoon, Vinay. Good afternoon. How are your preparations going on? Scared, happy, excited? What is it right now? Yeah, I'm audible. That's great. Okay. So today we are going to discuss the answers of negotiable, not the answers excited. Good afternoon. Good afternoon, Awad. Study buddy. I don't know what your name is, study buddy, but it's nice. It's always good to be excited. So you know that whole thing is there. Oh my God, I'm going to write the exams. That whole thing is there. So today you already know what we are going to do. We are going to discuss the questions of negotiable instruments, right? Varsha, still try to complete as much as possible special contracts. If not time, go through the questions at least. If something matches up, at least that you will be able to do. So that will kind of help you. Okay, if you're not able to complete, go to special contract. Generally they ask question, do that portion, right? Performance of the contract, generally they do ask questions from that, do that. Then rest of the time do the rest of the things. Okay. Good afternoon, Muhammad. Good afternoon. Good afternoon. So I'll start with negotiable instruments. Anything else you want to know before we start? Anything else that you guys want to know before we start? No? Can we start? Yes. So we'll start with negotiable instruments. Many of you had messaged that you wanted us to do a question on negotiable instruments. So we'll start with the questions on negotiable instruments. I hope you are, but anyway, yeah, because you have ample of time. See, guys, you do have ample of time. We cannot deny that. So I'm hoping that you are actually, just one second, huh? You are actually do going through the questions because you know how important going through the questions is, right? So I hope you are going through the questions and everything, right? Because after every topic, do go through the questions because that will give you a little more idea on everything. So starting with the question, the first question, this was in fact a question in your September paper only. This was a question from your September paper only. I'm going to read out the question. You please do, along with me, do tell me what will be the answer. And obviously, we are going to write it. So, Reliable Limited is an Indian company. An Indian company is a global leader in petrochemical products. For payment of the sale price of machinery imported from LX Manufacturing Limited, a US based company, the exporter, the Indian company drew a bill of exchange on Manish, a resident of Mumbai, who accepted the bill at Mumbai payable to the exporter in US. Decide whether the bill of exchange is an inland instrument. So this question is telling us very clearly you have to write about what? Inland foreign instrument, correct or not? You have to write about that. So that is the question. See, the question itself will give you the answer. If you can identify that, super good. If you can actually identify that, that's amazing. Because if you are able to identify what the question is asking you, then in that case, what do you say? It will be it will be easier for you to get the answer as well as, just let me open the chat once, please. The other one also. So it will be easier for you to identify as well as know what should be the answer, right? So anyway, moving on. So tell me, what do you think? What is the answer here? Tell me. What do you think is the answer here? Is it an inland instrument or is it not an inland instrument? Is it an inland instrument? So for an inland instrument, we need two things. Let's just write the provisions. So as per the provisions of, okay, as per the provisions of the Negotiable Instruments Act, sorry, not here, 1881, an instrument is an inland instrument. Okay. Yes, an instrument is an inland instrument if it is drawn in India, and so there are actually two things here. First is what? It has to be drawn in India mandatorily. Here, it was drawn by the Indian company, so and nothing is given. So obviously, because it's an Indian company, it is drawn in India and made and drawn on a person resident in India or made payable in India. So, first of all, what is important is that it has to be drawn in India, first point. And out of the second point, any one is enough. It has to be drawn on a person resident in India, or it has to be what? Drawn, made payable in India. Here it is payable in US. So this condition is not fulfilled, but it is drawn payable on a person who is a resident of India. So both the conditions are fulfilled. So we can say it's an inland instrument, right? Made payable in India. Any other instrument, any other instrument is a foreign instrument, right? Any other instrument is a foreign instrument. So this is my provision. Simple, nothing is there. Simple provision. So any other instrument is a foreign instrument. Therefore, so they are asking you, assume that the bill of exchange was signed by the authorized person for the drawer company. Decide whether the bill of exchange is an inland instrument or a foreign instrument. Therefore, and they have written it was signed by the authorized person for the drawer company. That means it's drawn in India. Therefore, the bill is an what? Inland instrument, right? The bill is an inland instrument. Moving on to the next one. M owes money to N. And the second one, M owes money to N. Therefore, he makes a promissory note for the amount in favor of N. For safety of transmission, he cuts the note in half and posts one half to N. He then changes his mind and calls upon N to return the half of the note which he had sent. N requires M to send the other half of the promissory note. Decide how the rights of the parties are to be adjusted. So you have to tell me this, guys. Who has a right over the instrument? Tell me. Who has a right over the instrument? So tell me, who has a right over the instrument? M will have a right over the instrument or N will have a right over the instrument? Tell me. Delivery of whole instrument is not done. Okay, Lavanya, agreed. So what in that case? If the whole instrument is not delivered, what in that case? Okay, M has a right over the instrument. Okay. So what answer will we write here? We have to write about the importance of delivery here, correct or not? We have to write about the importance of delivery. So as per the provisions, now two things I want to make it very clear here again as a reminder to all of you. It is absolutely not necessary for you to write the section number. So please don't get crazy about the section numbers. Oh my god, I don't remember the section number. What should I do? It is absolutely okay if you're not able to write the section number first. Second, there is no such hard and fast rule that you have to write word to word the law language. Yeah, the technical words have to be there. You cannot change them. But there is no hard and fast rule that, other than that, everything word to word you have to write. So please don't get crazy about that. It's absolutely okay if you don't write section number, because yesterday also someone had messaged me, ma'am, what if I don't write the section number? In that case, what will happen? So it's absolutely okay if you don't write the section numbers. Okay? So again, coming back, as per the provisions of the Negotiable Instruments Act 1881. Oh, okay, I have a question. Can you, instead of writing the full form of negotiable instrument, can you just write NI Act? Instead of writing negotiable instruments full, can you just write NI Act? No, you cannot. You should write full Negotiable Instruments Act, right? So, any instrument drawn has to be completed by delivery. Has to be completed by delivery. Now, delivery is essential not only at the time of not only at the time of endorsement, but also at the time of drawing of instrument. The delivery of the instrument may be actual or constructive. Also, because it is about part delivery. Even if you write all of this, but you don't talk about part delivery, it's an incomplete answer, because the question is actually about part delivery. Also, delivery must be of the whole of the instrument and not a part. Delivery of a part instrument shall not be considered. Delivery of a part instrument shall not be considered as a valid delivery. I hope this is clear to everyone. Yes? So, who can demand the promissory note? M. Therefore, M can demand back the half of the note, as the promissory note is not valid, as only a part was delivered. As only a part of it was, yeah, delivered. Correct? Is it clear to all of you? Is it clear to all of you? Yes. Can we go forward, guys? Can we go forward? Yes. So moving on to the next one, section 138. Yes, is definitely an important section, undoubted about that. It is definitely a very important section. Mr. Y issued a check for 10,000 to Mr. Z, which was dishonored by the bank because Y did not have enough funds in his account and has no authority to overdraw. Examine, as per the provisions of the Negotiable Instruments Act, whether Mr. Y is liable for dishonor of check. If yes, what are the consequences for such an offense? What would be your answer if Y issued a check as a donation to Mr. Z? So here, obviously, this it relates to section 138, correct? So we have to quote section 138. Since they have talked about punishment as well as they have talked about what happens if it was given as a donation, we will have to quote the entire section, right? So, as per the provisions of section negotiable instrument, you can write section 138 of the Negotiable Instruments Act 1881. When after the issue of check, it is dishonored, then the drawer shall be liable to imprisonment which can extend up to 2 years, or fine which can extend up to twice the amount of check, or both, right? The drawer can be made liable for the check if. Now I'm writing all the conditions of section 138. Now I will write, see, one more tip. I really need to share this tip with you all. Huh, correct, Vidhan. Correct. I really need to share one more tip with you all. If you have to write a lot of provisions in a question, now please understand, if the question is for 7 marks, multiple provisions are there. It should be a little more elaborate also. If it is 2 marks, it need not be elaborate. 3 marks, not that elaborate. So on the marks weightage also, you have to decide what content you have to write. Another thing, please understand, some of our handwriting is also, I have put this video also about tips to write. Be careful, you make sure you follow all of these things. Please understand, what happens is my handwriting is not good, or some of us, we don't go to the next line, we write everything in the same line. Please, if one point is over, go to the next line. Even if you don't give points, go to the next line and write. It gives a clarity to the person who is reading it. It's clear for him to understand, and also it is very beautiful to present. You don't have to write everything in the same line. Now, here, though, I'm going to write the provisions, the conditions for section 138. So, I have to write everything in point. Now, what will happen is I may start writing it as 1. But please understand another thing to be very careful in the exam. See, here my question also is 1 and 2. Now, if here also I write 1 and 2, my examiner can get confused whether it is the provision or whether I'm writing the conclusion. So please remember, if my question is 1, 2, here don't write 1, 2, please. You can use any other form of number except 1 or 2. Okay? So can I write it like this? Yes, you can write A, B, whatever. But don't write 1, 2 in the same way as it is given in the question. Okay? So now moving forward. So, however, the following conditions have to be fulfilled. First, it must be a it okay. My laptop has a mind of its own. So it must be for a lawful debt. Or you can write, and please don't see, when we write class notes, we write the keywords only. We don't write the whole sentence. Make sure in the exam you are at least writing the keywords. That's very important, please. So the first one, it must be for a lawful debt. That means the check is issued for some lawful debt. Second, it must be. What do I mean by it? You can write check must be. It must be, check must be presented within the time. What is the time? Validity of the check, or 3 months, whichever is earlier. Third, the holder gives a notice to the drawer about dishonor within 30 days of receipt of notice of dishonor from the bank. That means what? Section 138 is important from exam point of from the exam point, guys. So be careful about this section. So that means what? Once I have received a notice of dishonor, I actually give a from the bank I have received the notice. I within 30 days I give a notice to the drawer that look, your check has been dishonored. So a notice of dishonor from the bank, within that 30 days I give him a notice. And within 15 days, the drawer, within 15 days of notice, within 15 days of notice, the drawer fails to make payment on the check. Right? If these conditions are fulfilled, can the draw holder move against the drawer in the court of law? Yes. Acha, one more thing here, because that question is not there in the discussions here. One thing I want to discuss also, if you get question about stop payment, okay? So if you get a question that he issued the check and after that he gave an order for stop payment, then what you will write? I'm just writing it here. Okay. So, as per the provisions of negotiable instrument, because this is something related to 138, I'm writing that also. As per the provisions of section 138, a person, if in case of dishonor of check due to insufficiency of funds, a person is punishable to this offense, right? In case of stop payment, the drawer shall not be liable under section 130A. However, if the order for stop payment was given due to insufficiency of funds, right? If the order for stop payment was given due to insufficiency of funds, then the drawer shall be liable under section 138. So please make sure you write this whenever you are writing the answer. Clear? Make sure you write this whenever you are writing the answer. I hope it's clear to all of you. If the question is about stop payment, you have to add that. Now moving forward. So Mr. Y is liable for dishonor of check. If yes, what are the consequences for such offense? Therefore, what is the name? I forgot. See, I just read. Yeah. Therefore, Mr. Y shall be liable for dishonor as the account had insufficient funds, and he shall be punished by, same thing we'll write, imprisonment up to 2 years or fine which may extend to twice the amount of the check or both. Second, what is the second question? What would be your answer if Y issued a check as donation to Mr. Z? If the check was issued as a donation, it was not issued to set off or to pay any lawful debt. Hence, Mr. Y shall not be liable under section 138. I hope it's clear to all of you. I hope it's clear to everyone, guys. Yes. Can we go forward? Yes. Can we go forward? Mr. A made an endorsement of bill. Okay. Mr. A made an endorsement of bill of exchange amounting 50,000 to Mr. B. Mr. A made an endorsement of a bill of exchange amounting 50,000 to Mr. B, but before the same could be delivered to Mr. D, Mr. A passed away. Mr. A passed away. So here what happened, but before the same could be delivered to Mr. B, endorsement was made to Mr. B. But before the same could be delivered to Mr. B, Mr. A passed away. That means endorsement was done, but delivery was not done. And we already know that endorsement to be valid should be completed by delivery, otherwise it's not valid. Mr. S, son of Mr. A, who was the only legal representative of Mr. A, approached B and informed him about his father's death. Now, S is willing to complete the instrument. So, my question is, can any other person complete the endorsement on behalf of the endorser? No other person can complete the endorsement unless authorized, right? Unless authorized, no other person can complete the endorsement. So, let's look into this. As per the provisions of the Negotiable Instruments Act 1881, an instrument may be negotiated by endorsement and delivery. The delivery of the instrument may be actual or constructive. In case of endorsement, the the endorsement is not valid unless completed by delivery. So if instrument is not delivered, if instrument is not delivered, endorsement is not valid. The delivery can be done by any person on behalf of the endorser. Ma'am, why am I writing this? Because here the son is trying to endorse, right? That is why. On behalf of the endorser can be done by any person on behalf of the endorser if so authorized by the endorser, right? Can be what? Can be done on behalf of any person or on behalf of the endorser if so authorized by the endorser. In case of death of endorser, if delivery was not completed, the legal heirs cannot complete the delivery. Such delivery by legal heirs shall not be valid. वैसे if you see, we think negotiable का questions are difficult to answer, but if you look here, we have completed more questions in lesser time. And the provisions also, we have written everything full. The provisions are not that difficult if you've understood it. So now tell me, referring to the relevant provisions of decide whether Mr. S can complete the endorsement in the above scenario. So what is the answer? Therefore, Mr. S cannot complete the endorsement on behalf of his father, the endorser. Correct? I hope this is clear to all of you. Yes. Now I want to go to the next question. The last question, this is, I guess. Yeah. And this question, I want you to give me the answer. 2 minutes, read it, and then give me the answer, and then we'll move forward. Finished. Got the answer, guys? Tell me the answer. He will receive advocate's fees, Varsha. 18% interest to fine. But will he receive the advocate? She's deleted her message. She was right in her answer and she deleted the message. Yo, this no, undo your message is very bad. You have written the right answer and you undo it, huh? Okay. Okay. Sachin bought 100 kgs of rice from Saurav for 1,50,000 on 3 months credit. For this purpose, Sachin issued a promissory note to Saurav on the same date payable after 3 months. On the date of maturity, the promissory note was dishonored. Saurav filed a suit for the recovery of the amount plus fees of the advocate paid by him for defending the suit, referring to the provisions. So basically, the provision says what? You can recover the amount, yes. Can you recover any expense? Excuse me. We don't say damages, we rather put it like, Dhanush, be careful. In the exam, we don't write damages here. We write expenses incurred, right? Can he recover that? Yes. And he also has a right to recover 18% interest. So he will recover 1,50,000. Yes, exactly. Section 170. Correct. He will recover what? 1,50,000. He will recover the advocate's fees also. Yes. And he will also recover interest at the rate of 18%. Right? As per the provision of whatever. In case of dishonor of a negotiable, be careful. In the exam, you have written Indian Contract Act. First question, second question, negotiable. And you, instead of writing as per Negotiable Instruments Act, you write Indian Contract. Don't do all these blunders, okay? Dishonor of negotiable instrument. The holder shall be entitled to recover from the what drawer the following. First, he is entitled to receive the amount due on the instrument, right? First, amount due on the instrument together with any expenses incurred due to dishonor, right? Second, he is endorser is also liable to pay interest at the rate of 18% per annum on such amount from the date it was payable to the date it was finally recovered, right? And third, in case the holder resides at any place other than the place of payment, he will be entitled to receive the money as per the rate of exchange as on that day, right? Third point, ma'am, do I have to write? Well, if they say it is in some other country, then so it is mandatory. Otherwise, it's okay. So, what will be the answer? Therefore, Saurav has a right to recover. Saurav was the name, no? Sachin Hunt. Saurav has a right to recover. Saurav only, no? Was the question? Let me check. Huh. Saurav has a right to recover the amount of the bill, that is 1,50,000. He is also entitled to recover the advocate's fees and interest at the rate of 18%. I hope it's clear to all of you. I have tried to cover almost all the types. We have here covered all the types of different types of questions that you may get on this topic. I hope it is clear to all of you. So we've already given you so many tips on everything, what you should do, how you should do, and everything else. If you feel anything else you want to know, just drop a text. We will be there for you. We just couldn't do the question answer session of Indian Contract Act, but I hope you have been practicing that also, right? So with this, should I end the stream here, guys? Should I end the stream here? Yes, Dhanush, you want to ask anything? Dhanush, you want to ask anything? This is a wrong question to ask. Anything else? Anything else, guys? So I'll end the session here. Keep studying. You still have 1.5 days, which is actually too much. Also, you can, like, even if you have missed out anything, not revised, you still have ample of time to revise. Make sure you go through the questions, all the questions. Okay. Happy learning and stay motivated, guys. Bye, bye, bye. All the best, all the best, all the best.